Imagine waking up tomorrow and the military has replaced your local police. Your courts are closed, and your right to protest? Gone. No trial, no warrant, just soldiers enforcing the rules. That is martial law. And while it sounds like something out of a history book or a distant country, it is a real legal power that governments around the world have invoked throughout history, and as recently as 2024. So what exactly is martial law? Where does it come from? How has it been used? And what limits actually exist on it? Let us break it all down. At its core, martial law is the replacement of civilian government by military rule and the suspension of the civilian legal processes that normally protect your rights. According to legal scholars and institutions, including the Brennan Center for Justice, it typically allows the military to take the place of civilian government and exercise direct jurisdiction over ordinary people in a specific area. When martial law is in force, it can mean curfews, restrictions on travel, bans on public assembly, censorship of the press, and most critically, the suspension of habeas corpus, your fundamental right to demand that a court review whether your detention is lawful. Here's something that surprises most people. Despite being used dozens of times in history, martial law does not have a clear, settled legal definition in most countries. Legal experts at the Brennan Center note that no federal statute in the United States actually defines what the term means. Across history, the phrase has been used to describe a wide variety of actions and roles for the military, which has left its scope dangerously unclear. In fact, references to martial law in English legal tradition go all the way back to 1628, when one legal commentator described it as, quote, no law but something indulged rather than allowed as a law, a description that remarkably still applies in many countries today. So who can declare it? In the United States, the power to declare martial law can rest with the president, state governors, or in limited circumstances, a local military commander. But here's the critical nuance. The U.S. Constitution does not explicitly grant any single person the power to declare martial law. Legal analysis from the Brennan Center concludes that under current law, a president likely cannot declare it unilaterally without congressional authorization. State officials do have the power to declare it within their borders, but their actions are still subject to review by federal courts. Two major schools of thought exist among legal scholars. One holds that the power is a constitutional emergency authority, while the other argues it arises purely from necessity, a kind of last resort when normal government can no longer function. Now here's the part that really matters when we look at history, because the way martial law plays out on the ground varies enormously depending on who is using it and why. In the United States alone, martial law has been declared at least 68 times, according to research cited by military historians. Most of those cases involve state or local officials responding to labor unrest, riots, or natural disasters. At the federal level, it has been used twice during wartime. During the Civil War, military tribunals were used in states where local courts were unreliable or had broken down. In Hawaii, martial law was declared on December 7, 1941, immediately following the attack on Pearl Harbor, and the territory remained under military control from 1941 to 1944. The last formally declared instance of martial law in the United States took place in 1963 in Maryland in response to civil rights protests. The U.S. Supreme Court has weighed in on the limits of martial law in landmark rulings. In an 1866 case called Ex parte Milligan, the court established that trying civilians in military tribunals is unconstitutional when civilian courts are still open and functioning. The ruling famously stated that martial rule can never exist where the courts are open and unobstructed. That principle remains a cornerstone of how the legal community understands the boundaries of martial law today. Beyond the United States, the history of martial law around the world is even more striking, and in some cases, far more consequential for the people living under it. Syria's martial law regime, which began following a coup in 1963, lasted for nearly 50 consecutive years, making it the longest active period of martial law on record, according to historians. During that time, the martial law governor held extraordinary powers to restrict freedoms of movement, residence, and assembly, and to detain anyone suspected of endangering public order, essentially giving the military legal authority over virtually every aspect of daily life. In Poland in 1981, martial law was imposed amid rising political tension, resulting in curfews, nationwide travel bans, censorship, and food rationing. Approximately 91 deaths were attributed to the period of martial law, including miners killed during a crackdown on a strike. In the Philippines in 1972, martial law was declared amid political unrest and lasted for nearly a decade. According to historical records, tens of thousands of people, including students, journalists, academics, and religious leaders, were arbitrarily arrested, detained, and tortured during that period. The human rights toll was severe. In China in 1989, martial law was declared in Beijing during the Tiananmen Square protests. The military was deployed, and what followed was described by historians as a brutal crackdown that ended the protest movement.
More recently, Ukraine declared martial law in February 2022, following Russia's full-scale invasion of the country.
That declaration has been extended multiple times since, with Parliament approving a further 90-day renewal as recently as April 2025, according to reports, as the conflict continues into its fourth year. And then there is the case that brought martial law back into global headlines just over a year ago. In December 2024, South Korea's then president declared emergency martial law in a late-night televised address, accusing the opposition-controlled parliament of anti-state activities. The declaration suspended political activity, imposed restrictions on the press, and ordered the arrest of several political figures. It was the first declaration of martial law in South Korea since the country's transition to democracy in the late 1980s, and it lasted less than 7 hours. South Korea's National Assembly convened in an emergency session, with all 190 members present voting to block the decree. Under the South Korean constitution, that vote required the president to end martial law. He complied. The Constitutional Court later unanimously upheld the president's impeachment over the declaration. In February 2026, according to reports, the former president and others involved were found guilty on insurrection charges, a historic legal consequence that underscored just how seriously democratic institutions treat the misuse of martial law powers. So why does any of this matter right now? Because the South Korea episode, alongside Ukraine's ongoing martial law, has prompted legal scholars, legislators, and democratic institutions around the world to revisit a fundamental question. When emergency powers are this consequential and this poorly defined, what safeguards need to exist to prevent their abuse? In South Korea, according to legal analysts, several proposed amendment bills are being considered in the National Assembly that would tighten parliamentary control over the declaration of martial law and exclude certain serious crimes from amnesty protections. In the United States, the Brennan Center for Justice has argued that Congress and state legislatures need to enact clearer laws that define the scope and limits of martial law, because right now those boundaries remain, in their words, dangerously unclear. At the international level, legal scholars have noted that the International Court of Justice has, in multiple instances across different countries, expressed the view that martial law, when imposed outside of genuine necessity, conflicts with foundational principles of democracy and human rights, including protections outlined in international law. The pattern across centuries and continents is consistent. Martial law, when used as intended, to bridge a genuine emergency when civilian institutions have collapsed or cannot function, may serve its stated purpose. But when it is declared without legitimate necessity, or when it persists beyond the conditions that justified it, history shows it can become a tool for the permanent erosion of the very rights it claimed to protect. The core tension is this: every democratic government needs emergency powers to survive a real crisis. But every government also needs effective checks on those powers, so that declaring an emergency does not become a shortcut around democracy itself. What to watch for going forward? Legal reform debates in South Korea and the United States will likely shape how martial law powers are defined and constrained in democratic systems for years to come. And as conflicts and political crises continue in multiple regions globally, the question of when military rule is justified and who gets to decide remains one of the most consequential legal questions of our time. If you found this breakdown useful, follow this channel for daily deep dives into the stories and legal questions shaping the world.